Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Hi, welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Real Estate Group, and today we're joined by our host Jim York and his guest Celia Deifik, attorney with the law group Ross, Lanier, and Deifik.
Thank you, Morgan, for the introduction. Well, thanks for coming back on the show
Sure.
this month. Let's, for the viewers that haven't seen you on the show, let's just give them a little background about yourself, please.
Certainly. I am board certified in real property law since 1990 and recertified every 5 years thereafter with a law firm downtown Naples. I specialize in litigating real estate issues, consumer issues, business issues.
And your office is located where?
We are in the Capitol Bank building on the corner of 41 and 6th Avenue North.
Across from
Pastrami Dance.
Right,
Everybody always finds us when I say that.
That's right. So anybody familiar with Naples is familiar with that.
Yes. Yeah.
So I'm glad you came on the show today because, you know, when we, as real estate agents and owners and everything, we have these communities, associations that we deal with, and we don't necessarily have as many up north as we do down here. And they're good and bad. So I think what you're going to talk about today is over the overview, there's been a lot of changes this year in the laws governing the
Community associations.
Community associations.
Dramatic changes, one of the most dramatic changes that we've seen in some years. And interestingly, this arose out of a grand jury report in Miami-Dade County, which seems to be the area of the state where there has been the most corruption and fraud regarding condominiums and homeowners associations.
And what changes have you seen that they're implementing?
Well, one change that affects both homeowner associations and condominiums is a very broad new law with regard to estoppel certificates. I want to touch on something you mentioned, which is that there's more community associations in Florida, and in fact, even despite the recession, we've seen a huge explosion of the number of condominiums and homeowner associations. Estoppel certificates and the new laws governing them will affect everyone buying and selling, every real estate agent, every management company, and lenders as well.
Well, for the viewers that aren't familiar with estoppel letter, what is it for them?
Well, it used to be thought of as merely a short letter from the association or the association manager that said how much was due and owing in condominium assessments, whether there was a late fee. And it was a fairly simple document. Most condos and management companies would charge maybe $50 for this. Now, what happened was, since there's no law setting a limit, there were, particularly on the East Coast, management companies that were charging up to $1,700 for an estoppel certificate. So the legislature took this in hand and they said, you can charge $250 for a standard estoppel, but it has to have this long laundry list of information in it, some of which management companies might not be prepared to put in it. You can, for an additional $100, ask for an expedited estoppel certificate, and if there's a delinquency involved, you can, you being the association or the management company, add another $150. So you might be talking about $500. Interestingly, we've seen some management companies requiring the delinquency fee even where there is no delinquency, saying, well, maybe we'll give it back to you later. Additionally, this estoppel certificate has to have all kinds of information in it, which will be useful to the buyer and the title agent, but which the management company might not be qualified or prepared to fill out, and it may require them oddly, to engage in the unlicensed practice of law. So it's creating a rolling set of problems.
So if the association, the community association, doesn't provide you with all those things that's in the law, what happens then?
That is an excellent question, and that is unresolved. Certainly one of the problems with the estoppel certificates, and let's just define that a little bit further, it's just a funny legal word that means an affidavit, saying, if I tell you $650 is owed on assessments, you give me $650, I'm estopped from coming back and saying, oh, no, it was $900. Right. So it's an affidavit. The law does provide that if it is not provided by the management, then they have to refund the monies paid. But as you know, this can affect whether a closing is going to take place. And I can see a variety of types of litigation coming out from this. Of more concern here is how the legislature has now criminalized some aspects of compliance with the condominium law, not necessarily with regard to the estoppel certificate, but with regard to some of the newer requirements.
In the application, are they requiring the people to pay for this up front?
Yes.
They are?
Yes, and there's even been discussion among my colleagues as to whether or not the association can start to count the 10 days from when they get the check or when the check clears. The other odd thing is so many closing companies receive estoppel certificates by fax. And now the law says it has to be transmitted electronically or by U.S. mail. Does that mean it's not good if it's transmitted by fax? There's just a lot of oddities. And again, there's a lot of additional information that is useful, but it's going to make, I think, closings a bit more burdensome, and people are going to need a little bit more time.
So when we sell a condo or anywhere, they have to pay for the application fee. Okay. So up front. So the estoppel letter, is that going to be the buyer? Is he going to be able to? Does he have to pay for that up front, or does the closing agent pay for that? Do you know?
I think that's going to be addressed in revisions to the standard contracts. Generally, it has been the responsibility of the unit owner because it's his unit. Under the new law, anyone who asks for it, such as an agent on behalf of, is required to pay the funds, and the association is not required to provide it until they receive payment. Now, I suspect many still will when they're dealing with, closing agents with whom they're familiar, those kinds of things.
And in that estoppel letter, it has special assessments in that too?
It would have special assessments. It would have information as to whether or not the board has, or the association has, a right of first refusal with regard to the unit, information as to whether there's a capital contribution required, and information as to whether or not the board, whether or not a sale needs to be approved in writing by a board before it can go through. It's a big body of law in Florida that, with declarations that say a sale is not good unless approved in writing and a certificate recorded, then the sale is null and void. And I've litigated that issue years ago. So it can be a real issue because the management company may not be familiar with all of those aspects, and they're now going to be charged with reading the condominium declaration, which brings us to some other ambiguities in the law. It says, the new law says, that an association may not be represented by an attorney, may not hire an attorney who's also representing a management company. There's a whole slew of new laws concerning conflicts of interest. Now, it has been customary sometimes for management companies to have their in-house counsel prepare liens.
That's right.
Or do foreclosures. They will no longer be able to do that. It also creates a problem for insurance defense. For instance, if a condominium association is sued for whatever event, two things are going to happen. Number one, they're going to call upon their insurance carrier to provide a defense. Most condominium associations that have a contract with a management company, there is an indemnification clause in that contract where the manager is saying, if I get sued in the process of working for you, you will provide defense.
Right.
And so what has happened customarily is the insurance carrier comes in, appoints one law firm or one attorney who is going to represent the association and the management company. Apparently that will not be permitted. Insurance companies might then have to hire two different law firms, and what are they going to do? They're going to increase your premiums.
And it's just going to drive up the cost of everything. So, well, we're going to take a little short break
Okay.
here, and we're going to be back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Bonita Springs, or Estero? Think of the most experienced realtors. The York Real Estate Group of Downing Fry Realty. Let's have a look at what the McLeans have to say about their experience working with the York Real Estate Group.
Jim York was our broker in acquiring our present home in Bonita Springs. His knowledge and integrity made the process go very smoothly.
It was a pleasure doing business with Jim York. Everything was done in a superbly professional manner.
Welcome back. Let's talk about the liabilities of board of directors. I'm not sure I would want to be on one myself, but let's just talk about that. See, with the new laws and everything, has that changed also?
That has changed dramatically, again, as a result of the grand jury report, which, by the way, I'm posting on my blog if I have not already done so. There was a tremendous amount of corruption in Miami-Dade. These laws are a overreaction to that because the problem is not that widespread through Florida. There are many new restrictions on board members. As we all know, board members are volunteers.
That's right.
They are working often in their retirement for the good of their community. And this may dissuade some people from taking this on. A number of new provisions come down hard on any even appearance of a conflict of interest between a board member and any business that the association might do business with. There are much sterner recall provisions. It used to be that if a board member was recalled, there's a procedure set out in the statute. If it wasn't done properly, and sometimes these things were done in a quite sloppy fashion, the board member could challenge the recall. Now the recall, before it became effective, now the recall becomes effective immediately. And if the board member wants to challenge the recall, he or she might have to file a petition on her own dime. If she is found to have engaged in a conflict of interest, solicited business, or gotten any kind of kickback, or done anything that appears to be fraud, for instance, changing a ballot or the outside of a ballot, using a debit card now is prohibited. Not only will there be civil penalties for the board member, there also will be criminal penalties. It's a little hard to parse the statute because some things were always crimes. If you were an officer of a condominium and you embezzled funds from the association, we didn't need the condominium law to tell us that that was criminal.
That's right.
But the legislature has gone a little bit further to make sure everybody recognizes that some things are criminal. For instance, if I'm on a board and you make a records request, and I fail to provide the records to you, maybe I have an ulterior motive, I could be possibly convicted of obstruction of justice. If I am sorting ballots and inadvertently change something on the exterior of an envelope of a ballot or fail to count a ballot properly, am I exposing myself to some kind of criminal penalty? It becomes more questionable, more likely with the new law. It's difficult to give you a across-the-board definition of what is and isn't criminal under the new statute, except to say that boards should work very closely with their association counsel going forward, because things are far more perilous now.
So if somebody's asked for a budget, you know, receipts of whatever, the landscaping or whatever like that, they're usually asking the management company, they're
Yes.
asking the board member, but I guess if the management company doesn't give it and they ask the board member, they're liable too.
They could be liable. They could be liable. Now, one of the things that was happening, and here's another area where the law has expanded, is, again, in Miami-Dade,
Right.
There were board members who were in cahoots, so to speak, with management companies. And for instance, they would fail to send notices of assessments to certain unit owners, and then the unit would go into foreclosure, sometimes before the unit owner even knew what was going on, would go to sale, and the board member or management person would buy it. So
Right.
that has been, so now they have outlawed any board member, any manager, any employee of a management company, any employee of an association from purchasing a unit at a foreclosure sale. There are also now term limits, which are quite confusing. The new term limits for board members say you cannot serve more than 4 two-year terms. That would appear to be an 8-year limit, but most condominiums have staggered terms of 1 year and 2 years. It doesn't say anything about if you build up 8 years because you served a few 1-year terms and a few 2-year terms.
Right.
It also doesn't address if we're going to look back at your current term or prior terms. Is it retroactive? Now, the word is that the Division of Condominiums is going to come out with some administrative rules that are going to make clear it's not retroactive. But it's extremely puzzling. Now, I am active in some committees of the real property section of the bar, and we're already talking about working with legislators on what we're calling a glitch bill for next year, because some provisions of the law just outright contradict each other. There's a new provision that the association may not use debit cards. Doesn't say anything about credit cards. It says you may not use debit cards. And then in another place it says if you use a debit card, you can only use it for X, Y, and Z. Well, which is it? People are confused.
Yeah, it's you know, they write these laws and they really don't think them through. Similar to maybe Obamacare, right?
Yeah.
So where do we go from here?
Well,
You think
I think.
after we scared everybody?
Well, let's see, who does this help? Obviously, it helps attorneys. The
Right.
legislature.
We figured that one out.
The legislature is always writing full employment bills
Right.
for attorneys. It does help unit owners who are frustrated with their board because it gives them more remedies, and it makes those remedies more stronger.
Right.
It makes those remedies stronger. So for someone such as myself, who often finds myself litigating on behalf of unit owners or of condominiums, of homeowner associations, various kinds of community associations, golf clubs, things like that, which golf clubs aren't covered, it gives us more tools. I can't say that I'm happy about that, though, because I think some of these might be unfair. I'm certainly not going to go accusing board members of crimes because they may have inadvertently done something.
Right.
Now, those board members out there who are deliberately taking advantage of the
That's right,
of the
yeah.
purse of the condominium association, those people need to beware. There's a lot of other things that are helpful. For instance, now the association has to every year send to the Division of Condominiums a very detailed list of where their financial accounts are, at what institutions, you know, things like that. And any unit owner who wants that information can request it from the division. That seemed a bit odd to me, since you can always request it from your own
That's right,
association.
right.
One of the things I find frustrating in my practice is we have so many people come to us and they say, I need to hire a lawyer because I want to get such and such information from the association. To which I say, or my paralegal says, have you written a letter and asked for it?
Mm-hmm.
Well, I don't think they'll respond. There's a law that says they have to.
In so many days?
Yes,
In so many days. they're
yes. Mhm.
And if they don't, what's the penalty for that?
The penalty can be damages, and it can be attorney's fees. So, yes. You know, the interesting thing that I've seen in my practice is when I started practicing several decades ago, we're not going to say how many, the condominium statute was very thin.
Right.
And each year it's gotten
Bigger and bigger.
bigger and bigger and bigger, and the number of court decisions under it have grown exponentially. And in addition to that, the administrative rules put out by the Division of Condominiums have grown, and they're constantly changing. One good change that I am happy about is the legislature had instituted a system of arbitration for condominiums to try and give people an avenue that wasn't litigation, that would be cheaper and quicker, so that you could arbitrate or mediate through the Division of Condominiums certain types of disputes that were very common. Unfortunately, the division has gotten so bogged down that it's not any faster than litigation, and sometimes not cheaper. So one thing the legislature did is they said, listen, we think one of the problems is that the Division of Condominiums is only using in-house arbitrators, in other words, people who are employees of the state. Number one, they have too many cases. Number two, some of those people are not that well qualified. So we're going to permit the Division of Condominiums to appoint outside attorneys who may have certain qualifications to serve as arbitrators or mediators. Well, you can always pick mediators. That was decided some time ago. The state used to try and keep a hold of it. And they have set out some very strict requirements for attorneys who want to serve as arbitrators. I think that's going to be helpful for both the associations and the owners. Things may move more quickly, especially if you can select someone in your community.
Right.
And it might cut the cost down and save you from litigation.
Well, I've learned a lot today.
Okay.
So I think our viewers have, and I'm really thankful for you coming on the show and giving us this input, and hopefully it all works out for the best for the board members, the associations, and the homeowners.
Knowledge is power.
It is, it really is. So thank you for joining us today. Thank you.
Thank you.